Hello, everybody. Hello, Billy. Oh, hi, buddy. Hold on, I gotta get my phone out of my pocket. Hold on, can I turn my ringer off so that like people aren't interrupting my stream? I know I should have been more prepared. I'm a terrible host. Hi, Ava. Oh my goodness. Okay. Here. I hear more coming. Here. I gotta sprinkle them around or he gobbles them up so quickly. So I gotta sprinkle him around to slow him down. Okay. So I managed to stumble across something fun. So before we get into the case, I want to show you, as I was looking up additional hearings. So this is the case that we're going to be looking at tonight, okay? So and this isn't even all of it, okay? Just, you know, there was a lot. This is mostly stuff that happened on the back end, like, notices to appear and answers filed and things like that. Most of it's back end stuff, but this is just to show you how active of a case this has been. This person has been putting a lot of effort into this case. And that's after this one, which is the same case, but this is the closed status version. So yeah. They're suing in small claims in Allegan County, Michigan for $7,000. That's their claim of losses. So we get to enjoy this tonight. Oh my! Oh, I'm so happy to have you with us. Hello. Let's see, is it Just Family Videos 2064? Thank you so much for joining. Joey Big of Donuts, thank you so much. And Great Granny. Oh, you are so sweet. Hello, Lissapanette. Hello, Nana Laura. Granny Janie sent me a picture of all of the white stuff that she has at her place. It's a lot more than I got. We got some drizzly rain. It might freeze, but we don't have an accumulation of the white stuff right now. Hello, C-Rex, honey. Hello, Jerry Matthew Boyd. Oh, Florida. Where so much great content comes from. Hello, Wire Mother. Hello, Eileen and Carlin. You guys are just amazing. Hello, Fargan Vestige. Yeah, he was making his presence known. All 17-ish pounds of him. Well, he's jealous of Ava being the star of the show. Hello, Spider-Man, honey. Hello, Mortimer Duke. True story. Actually, my neighbor absolutely loves it. He says this is his time of year. He can keep it. All to himself. See, there are some people. All right, let's get into this absolute clown show. Our main character tonight is pro se. Need I say more? He's obnoxious, rude, loud, uneducated, all of the usuals.
All right, let's go on the record in the matter of Gerald Kusarchik versus Mimic Insurance, file 2402891R Let's have appearance, please.
Gerald Kusarchik.
Okay, and counsel.
Attorney Stuart Wiesner on behalf of Mimic, Your Honor.
Very good.
Who?
Who would like to proceed?
Judge, this attorney isn't even a part of the record.
Well, he is now. So please proceed, counsel.
The same law firm as Mr. Scrotenboy, Your Honor. So
that's fine. I don't have a problem with that.
Okay.
Please proceed, counsel. I'm sorry. Please proceed, Mr. Kusarchik.
Okay, I guess where do we start? Do we start from November 8th of 2024 and proceed through today with our motions? Or do we start with summary disposition?
We are only doing the summary disposition.
Oh. Well, man. Okay, let me put this aside. I've got all, I didn't know it said motion, so,
The
okay.
motion,
Yes, Your Honor?
this is your motion the counter motion or the initial motion of summary disposition?
Mine's the initial.
All right, so please proceed.
Okay, so I have a motion and support the motion for summary disposition, including sua sponte request. Defendants failed to reply to my interrogatories, request for production, request for admissions. All would be deemed admissible under law. They're finding of no genuine issue of matter and granting finding there is no genuine issue of matter and granting summary disposition for plaintiff under MCR 2.116 C10 is appropriate. Alternatively, granting judgment summa sponte without delay and with appropriate notice under MCR 2.116 IA is be appropriate.
So you're saying that there's no genuine issue of fact?
If the defendant failed to reply to my discovery, how can there be an issue of fact? I can't get any facts from them. So my fact stands, right? That there was damage to my vehicle. There was a contract between me and MEMIC. My agent told me to file a claim. They denied the claim, and they refused discovery. I filed summary disposition. They counter-replied. They included an affidavit that should be denied because it should have came under discovery. They have done so many bad things here, and yet I can go on and on. Now, where should I start? I'll start with a statement of facts and go through it. Is that how we do this?
Well, I mean, you don't need to read me your motion. What I need you to do is make your argument here so that I can then hear the argument of the defendant.
Okay. When I originally applied in small claims, they moved it over to district. And then they asked for, they said venue and jurisdiction, all that was wrong. And then they used the issue then they come up with that I had no issue so they could dismiss it. Or that I was in non-compliance. And everything states that they are in non-compliance. In fact, their claim states that a loss is for sudden physical damage. What does that mean? Sudden physical. It's only what you can see, or is it the damage that you can't see? Did he only take pictures but what can you see in a picture if a frame is cracked or an axle is bent or a shaft is twisted?
Sudden physical damage would be any damage that happens as a result of an instant action, not prolonged over a long course of time. It doesn't matter if you can see it when looking at it or not see it when looking at it. It's just a matter of how much time has passed for the damage to have occurred.
Do you have documentation of those damages, sir?
I have an estimate from the garage, yes. He looked with a flashlight and said that there was sludge. Sludge is from greasing it and driving down Bryan on a road and getting dust on it. He said there were seals that were dry rotted. No, them were dust covers on my tie rods. They weren't dry rotted. one was collapsed and one was bulged. Could it be from hitting a hole hard and swerving that they bulged and collapsed? Yes. I presented my case, and they keep coming up with something, or they don't answer, and then they came up with this affidavit that is total meaningless. Interrogatories that are not admitted to, are not replied to, are admitted. So all my interrogatories...
Sir, requests for admissions that are not responded to are admitted. Interrogatories not responded to are nothing unless you do a motion pertaining to that.
This is what I have. I'm sorry, I misread it. Unanswered requests for admissions are deemed admitted and establish plaintiff's claim. So in my admissions, I had all this in it, and they refused to reply to it. Also, the law states that each admission is requested and admitted within 28 days after service. This is in Medley versus Walsh. The court held that unanswered admissions conclusively establish the truth of the matter admitted and may support summary disposition. Likewise, MCR 2.312 D2, Ratty versus Miller, Canfield, Paddock, and Stone. Admissions are conclusive in the pending action. Defendant failed to timely answer plaintiff's request for admission. So the answer is yes, summary disposition is appropriate. These are case studies. I don't know what else I go.
All right, Mr. Wiesner.
Just briefly, Your Honor, to clear up the discovery issue, the court entered an order on February 10th giving 60 days. The discovery served by Mr. Kucharek were outside that period. So that probably is the answer. That may settle the discovery issue, or what he's talking about are serving interrogatories. This case, Your Honor, just a quick overview for you so you have an idea. Mr. Sapala is a certified auto mechanic. We attached his affidavit. He went out and inspected Mr. Kucharek's truck. He determined, based on his years of experience doing physical, as a physical damage auto adjuster, as well as, his mechanic skills, that this was not a sudden and accidental loss. He wrote Mr. Kucharek a letter indicating that. Mr. Kucharek may have an estimate, but an estimate, in and of itself doesn't necessarily convey that this was a sudden and accidental loss either, Your Honor. That's why Mr. Scrotenboer went to the steps of getting Mr. Sapala to, prepare an affidavit. As the court's probably aware, I'm not a mechanic. I don't know if Your Honor dabbles in, auto repair. I certainly don't. I'm not sure if even Mr. Kucharek does, but Mr. Sapala does know.
He dabbles in auto repair and law, apparently.
Mr. Sapala is a certified auto mechanic and can testify to these things. When one files a motion for summary disposition, Your Honor, the whole point is that you file something, and if the other side needs to file a response to address, the issues at hand. In this case, while, he can say, well, I had an estimate, that doesn't necessarily indicate that the damage that, is talked about in the the condition of his car that Mr. Sapala addresses in our, counter motion for summary disposition. It clearly indicates that he believes this was a maintenance issue. It was not a sudden and accidental loss. And, cited both the exclusion in his letter to Mr. Kucharek, as well as, our interpretation of the insurance policy. So we're here today essentially to say who has brought forth proof, who didn't, essentially is what a motion for summary disposition is. And I would ask the court that we did come forth with evidence, and it has not been rebutted by Mr. Kucharek.
Your Honor, can I reply to that?
You may.
I asked on April 11th, I asked defendants if they would settle this out of court. They refused to reply. On April 17th, they replied that they were inclined not to. That's when I filed my discovery. So that has nothing to do with their inability to reply. They had from February or from April 11th till now to reply, and they never did.
Well, but what you're doing, you're requiring a hard and fast reading of court rules pertaining to the request for admission, but at the same time ignoring the order closing discovery that this court imposed. So you may have a point, sir. Frankly, I think both of you have highlighted sufficient basis for me to indicate that this is a matter that needs to be set for trial. So I'm going to be denying both. I'm going to be denying both motions without prejudice and set the matter for trial.
Thank you.
Will you be sending us out a date now, or does the court want to give a date now, or?
I will have the court send out a notice for the trial.
All right. Thank you, Your Honor.
Okay. Thank you, Your Honor.
You're welcome.
From small claims to general civil. December 30th, 2024, is when defendant filed their answer, their jury demand, and their witness list. On January 7th, 2025, a jury fee was paid. January 13, 2025, plaintiff filed an answer. February 10, 2025, a pretrial conference was conducted before Judge Belargian. On February 11, 2025, the pretrial order was signed by the judge. The first page of that pretrial order indicates that the failure of any party to suggest changes and or amendments to this summary and order within 7 days of the date hereof will constitute a waiver of any claimed defect thereto. To date, no objections have been filed to this and no suggested changes have been requested. Page 2 of the pretrial order indicates that the pleadings are complete. It also indicates that discovery was open and to be completed within 60 days. As Mr. Strodenmore is aware, and Mr. Kostarzik should be aware, there is no discovery by right in district court. It's by leave only. And the court granted 60 days of discovery. After that discovery closed, there is no discovery unless the court directs otherwise. And the court has not directed otherwise. Page 3, the court indicated that plaintiff had one expert to extent and cause of damage, only one expert. Defendant had extent of and cause of damage. Other witnesses, plaintiff, self and agent to be disclosed within 30 days, defendant, repair shop, adjuster, and plaintiff to be disclosed within 30 days. On February 12, 2025, the court scheduled this matter for a trial on June 9, 2025. April 3, 2025, plaintiff filed an amended complaint without leave of the court. April 11, 2025, discovery closed. April 17, 2025, plaintiff filed a discovery request, and that was after discovery was closed. April 24, 2025, plaintiff filed a motion for leave to file summons and complaint. May 5, 2025, the court granted a motion for leave to file motion and complaint. June 5, motions for summary disposition were filed. June 6, bench trial was adjourned and the motion fees were paid. July 1, 2025, Mr. Scrutenborg filed his appearance. July 11, motions for summary disposition were noticed up. July 18, 2025, that's when the plaintiff filed his amended complaint. That was approximately 75 days after the court allowed that to be done. July 21, 2025, hearings on summary disposition were conducted and denied. July 22nd, an order denying the motions for summary disposition were entered by the court. August 11, 2025, a trial brief was filed by defendant. July 27, 2025 was a jury trial date that did not go due to a criminal case taking precedence. And then, I'm sorry, this is order July 24, 2025, defendant filed an answer to plaintiff's amended complaint and affirmative defenses. So the court goes back, when there are questions, the court goes back and looks at the civil pretrial summary and order. That is what both sides are obligated to follow, and that gives us our directions. So we have a number of issues before the court this morning, and the way the court interprets this is that discovery closed on April 11th. Anything that was filed subsequent to April 11 is irrelevant and is not enforceable. So any requests that Mr. Kasarczyk filed, discovery requests, if they were filed after April 11, those are not valid. That would include all of the documents, sir, that you filed in this month or anytime from April 11 to the present. You understand that, Mr. Kasarczyk?
Yes.
Also, the amended complaint that was filed July 18, 2025, that was 75 days approximately after the court granted leave. That is not timely. That appears to the court to be done as a method to harass the defendant. That is not timely. They cannot, when there have been trial dates that have been scheduled in the ensuing time, that is not, it's not appropriate to do. It does not allow, if the court were to allow that to proceed, that would essentially reopen everything and start everything from square one. I don't believe that that's fair to the plaintiff either. This plaintiff deserves an opportunity to be heard in a timely manner. But we're going to be working off the original complaint. We're going to be working off the original witnesses. And in that regard, the plaintiff filed subpoenas which were not properly noticed of. They were signed by Mr. Kasarczyk. Mr. Kasarczyk cannot sign a subpoena on his own. He is not an attorney. He is not an officer of the court. He cannot sign a subpoena. He did get the clerk to sign subpoenas on his behalf. And those subpoenas were directing production of documents. As the court noted, discovery closed on April 11th. Mr. Kasarczyk knew, or certainly should have known, that discovery was closed. And discovery closed approximately 5 months previously.
I wonder if he thinks he can notarize his own documents too.
So those are not appropriate either. The defendant filed a motion for sanctions. Defendant filed a motion to quash subpoena for protective order and for sanctions. Mr. Kasarczyk filed subpoenas on the president of MEMIC, a Joseph Richardson Jr. There is zero indication that Mr. Richardson has any indication of this lawsuit. This was done in an attempt to harass Mimic, harass the CEO, Mr. Richardson, and there's no valid reason for that subpoena. Along with the subpoenas, there were numerous attachments requesting various documents. Those, the plaintiff should know, were not meaningful or relevant or discoverable at this stage in the proceeding. The only witnesses that may be called are the witnesses that are listed on the pretrial order, which would be, according to the order that was signed, would be one expert to extent and cause damage only, one expert. And for defendant, extent and cause of damage, and other late witnesses would be self and agent for the plaintiff, and for defendant, repair shop, adjuster, and plaintiff. That would be at most five witnesses, 2 experts, 3 lay. Anything beyond that is not going to be enforceable by this court. This plaintiff is entitled to a trial. He's not entitled to anything beyond what has been ordered by this court or what the court rules allow. The court intends to have a well-run trial on Wednesday. The court does not expect any issues outside of normal objections. The court anticipates both parties to be at the courthouse and ready to go by 8 o'clock on Wednesday. The jury will be here 8 o'clock Wednesday. We will start at 8:30 promptly. I anticipate that there may be something that needs to be discussed before the jury trial starts at 8:30 on Wednesday. That's why both sides are directed to be present at 8 o'clock. The court is taking the issue of sanctions under advisement at this point in time in reference to the plaintiff's subpoena request. In reference to the case, we are not proceeding on any of these other issues, Mr. Kasarsik, that you've raised, such as uniform trade practice violations, whistleblower protection, invasion of privacy, libel, and slander. We are proceeding under the original complaint. Do you understand that, Mr. Kasarsik? Mr. Kasarsik, can you hear me?
No,
Oh,
I haven't
man.
heard nothing.
Oh, man.
At this point, Mr. Kasarsik, the court is considering various options. And how soon could you get before the court, Mr. Kasarsik, in person?
Could you, I can't, what'd you say? Your Honor,
How soon could
you said
how soon
something,
could you get to my courtroom?
what do you mean, today?
Yes.
I have a doctor's appointment this afternoon at 1:30. I could get there probably anytime before. Or
Could we,
1:15, I gotta be at the,
If I directed him to be here in person, could we get back on the record on this?
Of course, Judge. When do you want to do?
I'm directing you to be here as soon as possible.
okay? I'll be there then.
Your Honor, I have a question for the court. May I be heard? Your Honor, in my understanding, the court is ruling in favor of my motion to quash those subpoenas and for protective order that my clients need not comply.
Mr. Skronborg, the only thing that would be enforceable would be appearance in reference to any witness that was listed. So I can't recall if if the agent was one, he would need to be present for the trial.
Yeah, Mr. Harding will be, Mr. Kurt Harding. He's an agent of MEMIC, appearing on behalf of MEMIC. Will be appearing on Wednesday along with Mr. Cephala, who is a named defendant. He will be appearing. Those are the only two witnesses for the defense.
And Mr. Scrumborg, the court does not believe that Cephala was properly named because the original complaint was only against MEMIC.
Well, okay. So he's no longer a party?
I believe that he was not named.
Yes, he was.
He was not. Mr. Kasarczyk, you can be here in person. If you can't hear the court, you need to be here in person.
You're
He was
cutting in
not
and out. How am I supposed to? Never mind.
My understanding is that Cephala was not named until an amended complaint. Is that accurate, Mr. Scrumborg?
You know, I don't specifically recall that, but he was the, he's my expert on the issue, and an expert was identified and that we would be calling an expert. He's the guy who did the examination of the vehicle. Plaintiff has known about that for the longest time. So Mr. Cephala is an expert. He will be qualified at trial to explain our position. And by the way, when plaintiff appears live, he does not have an expert. He told me that before. He cannot prove his case without an expert. And
I
so,
did not tell you that.
That is an issue that the court is concerned about. The court does not know how Mr. Kasarczyk will meet his burden.
I have a strategy. Defense has tried to get that strategy through intimidation, and it didn't work. Now they're pulling all this at the
Mr.
court.
Kasarczyk, the court is directing you to be here in person. I expect you to
I'll
get
be
your
there.
car and get here right now. Mr. Scrumborg, we're going to go off the record here, and as soon as Mr. Kasarczyk appears in person, we're going to bring you back in. You can appear by technology if yours is working.
I have no idea.
well, my technology is obviously working, Your Honor. When would you like me to try to sign on again?
The court can give you a call.
Okay.
Is that acceptable?
Oh, sure. My cell number, Your Honor, is 616.
Okay. Okay, we'll give you a call when Mr. Kasarczyk. And Mr. Kasarczyk, can you still hear me? This is the court speaking, Mr. Kasarczyk.
Here
If
in
you are not
part,
here, in person before the court by 11 a.m. today, this case will be dismissed.
I didn't hear nothing.
I heard this case.
I didn't hear nothing.
If you are not in my courtroom, if you are not in this courtroom by 11 a.m., your case will be dismissed.
I'll be there.
That would be without prejudice.
Your Honor, before we leave this session, may I report to Mr. Richardson, who is the CEO of MEMIC, that he is not being required by the court to appear on Wednesday.
That
He
is accurate.
signed the contract.
That is accurate, Mr. Scrumborg.
Thank you, Your Honor. So may I leave and then wait for your call when he arrives?
Correct. And the court has plenty of other issues on the docket today, but this is very important to address. And so that's why we're doing this.
Understood, Your Honor. I'll wait for the court's call. And, yeah, I have other matters as well, but, you're the judge. I'll wait for the court's call.
Thank you.
Thank you.
So going through the file, the plaintiff filed his small claims complaint on November 8, 2024. On December 18, 2024, defendant filed an appearance. On December 19, 2024, the case was removed from small claims to general civil. On December 30th, 2024, defendant filed an answer, jury demand, and witness list. On July 7, 2025, the jury fee was paid. January 13, 2025, plaintiff filed his answer. And on February 10, 2025, a pretrial was conducted. That pretrial order was signed by Judge Belargin on February 11, 2025. The very first page of the civil pretrial summary and order indicates that the failure of any party to suggest changes and or amendments to this summary and order within 7 days of the date hereof will constitute a waiver of any claimed defect thereto. Nothing was filed within 7 days objecting to this pretrial, and nothing has been filed subsequent to those 7 days objecting to this pretrial order. So this pretrial order is what we are working off of. The pretrial on page 2 indicates the pleadings are complete. The issues and theories of the party indicate extent, cause, and calculation. Is it vehicle versus personal damage? Discovery was open for 60 days. Mr. Pisarcik, there is no discovery as of right in district court. Discovery in district court is by leave of the court. So the only discovery that's allowable is what the court permits. The court permitted 60 days for discovery.
I had motion.
No, you're not talking right now, okay? The pretrial order indicated one expert for the plaintiff to extent and cause of damage, only one expert. Defendant, extent and cause of damage. Other witnesses, those would be the lay witnesses, plaintiff, self and agent, to be disclosed within 30 days. Defendant, repair shop, adjuster, and plaintiff, to be disclosed in 30 days. Failure to comply will result in the testimony being excluded. Trial would be after 90 days. On February 12, 2025, the court scheduled trial for June 9, 2025. On April 3, 2025, the plaintiff filed an amended complaint without leave of the court. On April 11, 2025, discovery closed. April 17, 2025, plaintiff filed a discovery request. That was done after discovery had closed. April 24, 2025, plaintiff filed a motion for leave to file summons and complaint. May 5, 2025, the court granted a motion for leave to file summons and complaint. June 5, 2025, a motion for summary disposition was filed. June 6, 2025, the bench trial was adjourned. Motion fees were paid. July 1, 2025, Mr. Scrumenboer filed his appearance. On July 11, 2025, motion for summary disposition was noticed for hearing. On July 18, 2025, That's when the plaintiff filed his amended complaint. That was 75 days after the court granted leave. July 21, 2025, hearings on summary disposition were conducted and denied. July 22nd, 2025, the order denying motions for summary disposition was entered by court. On July 24, 2025, defendant filed an answer to plaintiff's amended complaint and affirmative defenses. July 11, 2025, the trial brief was filed by defendant, and August 27, 2025, the jury trial was scheduled, parties appeared, but it did not get conducted. So where we're at today is we have a trial scheduled for Wednesday. That trial on Wednesday will be a trial on defendant's original complaint. The defendant did not comply with the court order in terms of discovery. So any discovery that was filed after April 11, 2025 has no relevance and is not permitted by this court. The amended complaint that was filed by the plaintiff July 18, 2025 was filed approximately 75 days after the court granted leave. That is not timely. That is not fair to the parties in this case, including the plaintiff. If that were to be allowed, then that would reopen this entire case and there would not be resolution being anticipated as of Wednesday. So the subpoenas that were prepared by the plaintiff, where plaintiff signed his own name as an attorney or as a court officer, are not valid. The subpoenas that were authorized by the court clerk, those are not valid as far as discovery goes. Discovery had closed April 11, 2025. You cannot be asking for documents on the eve of trial from people that have no bearing on this case. What the court believes was intended by the plaintiff serving the CEO of Mimic Insurance was to harass or annoy that individual.
It is not a good sign when the other side is asking for sanctions and you have a judge saying that you're only filing things to harass them. It doesn't bode well for you, I would presume.
The individual has no knowledge of Mr. Kasarczyk or this case. The individuals that were subpoenaed who are listed on the pretrial, those subpoenas are valid only for appearance. So as to the plaintiff's subpoena to the agent, that would be appropriate for appearance, not for production of any documents. If Mr. Kasarczyk subpoenaed the expert to extent and cause of damage, well, for appearance, that could be valid. However, we do not have a CV, we do not have any sort of anticipated testimony from any expert on Mr. Kasarczyk's behalf. Even if Mr. Kasarczyk was able to lay the proper foundation for expert testimony, that expert would not be able to testify that this accident did in fact happen. what the court is going to do is, as of today, it is not going to order sanctions. Court is going to take the request for sanctions under advisement.
Well, sanctions for what? I'm not.
Defendant filed an emergency motion to quash subpoena for protective order and for sanctions. Plaintiff filed a response. So plaintiff is aware that that is being requested of him. If this case goes to trial and it's determined that there's a basis for sanctions, the court could authorize fines, costs, or attorney fees against either party, depending on how the proofs come in. The court is indicating and has indicated already that the subpoena as to the CEO of MEMIC Insurance is quashed. That is not a good subpoena. There's no basis for that. Mr. Kusarczyk, who is Adam Brock?
Shop owner. Andrew, not Adam.
And Andrew Brock. And what will his testimony be?
Your Honor, you got the defense right there. I'm not giving my strategy away.
Okay. Well,
The defense is right there. He asked for my strategy when we had the conference hearing, and he told me I had no basis because he's an officer of the court. He can do what he wants. Now, I wouldn't give him a strategy then. I'm not giving my strategy now.
what I'm doing, sir, is I'm putting you on notice that if there's not a basis for this lawsuit, and if this is deemed to be harassing, or if there's not a valid basis for this, then the court could sanction you
I understand
with
that.
actual attorney fees.
But why can't you sanction him too? You've never mentioned a sanction against him.
Because what is being,
Let's, can I go through some of my notes?
no, you may
Okay.
not.
So I can't question anything. I just gotta walk away. You give them what they want. I get nothing and we're done. Until
Sir,
trial.
you have your right to a jury trial.
But I had motions for 10 months and never got heard.
They were not properly done, sir. You have been pro per, you have had the opportunity to retake it, do not overtalk the
I'm
court.
not, okay.
You have violated order after order, sir. You know what the court scheduling order said. This is not legalese. This is not hard to follow.
Do we help concerns in good cause? I filed motions on this. I've had 2 surgeries this year. I'm expecting a 3rd one. I didn't get it this week because I got trial coming up. Now, I filed this in a motion for good cause. I showed it. I filed motions for leave of cause. When I talked to Judge Belladron a number of times, he repeatedly stated, as does Michigan court rules, about leniency for pro se defendants or litigants. I can bring it up. It's all in here. I can bring it back. We can refile this. Motions have not been heard. I am prejudiced because the court hasn't heard them. I haven't
There's no
gotten.
basis for your motions, sir. The court has reviewed everything. The court has reviewed this entire file multiple times.
Discovery was 5 months ago.
Discovery closed April 11.
I asked. Okay. Let's go
Nothing
back.
was filed
Let's
until
go back.
April
30 days. They were supposed to, they filed nothing in 30 days. They filed it 5 or 6 days late. It was accepted by the court, then it got thrown out. 60 days later, I asked them on the 11th if they were gonna settle. They waited 6 days and said, no, I filed for discovery. They filed nothing. Nothing got said. Okay. I waited 9 months not knowing, and I'm not prejudiced, and then wait 9 months not knowing enough. Discovery subpoenas, and I have the right to go back and ask if I didn't receive, as far as I understand. Now, I'll bring court rule, I'll bring paper rule if you want. I'll wait for answers for them, okay. I did not file against Mr. Richardson because I did not find his name until August 26th when they finally sent me the document of the policy. Who signed the policy was Mr. Richardson, and he signed it. He's responsible for what's in that policy, according to what the law says. Now, if that's changed, again, it's against me. I misunderstood it. How about witness tampering? We left the courtroom, sir, talked to my employee left without getting my money from him for travels and got hostile and said he was gonna get an attorney to represent him. What happened? He talked with my agent. My agent told me so. He told me so. He told me that they both had nothing to say that would help me. He told me that I had nothing because I wasn't an officer of the court. I asked a motion to hear this. Nothing got heard. Why? Because I'm pro se. He's an attorney. This is all legal. Now, how about defendant not following your order on August 27th? You told us to go in the conference room, to go over the jury instructions, to come back with jury instructions. I did not agree with Schultenberger's jury instructions. He did not come back and tell you anything. I heard nothing. 7 days later, I filed that I want my instructions accepted. Court did not find them in error or nothing. Okay. How about court clerk telling me that I have the right to find and sign the subpoena? Is this just a horse and pony show? I did all that work for nothing. You know how much that cost me, how much time and my health? I can't help it. The court told me that I could sign the subpoenas repeatedly. I signed them. He told me on August 24th, when the hearing was canceled, I have no say in this, that I'm not an officer of the court. He didn't look at the subpoenas. He didn't know what was in them. Again, a waste of my time. Lori Tange called me and told me to refile my subpoena so you approved her signing them. Now, why did you throw them out? Why sign them? I'm missing something here. I really am. My witness list was to the court and on time. I had myself, my wife, my daughter, my agent, and the shop owner. Plus, I was trying to get a mechanic. So I don't know where you got that. That wasn't, because that's been in files. Motion for leave had good cause, but court refused. Again, I cited numerous causes from Michigan rules of court rules and from cited cases. They're in here. I can bring them back up. I will. Court admonished me for not having a good phone or computer. Who owns this equipment in here?
Are you done?
No. Who owns the court? Who is this court? Whose court is this? You admonished me because I have computer. I've been at 3 places trying to get this done, and you admonished me because I don't have great technology or I don't have the money to buy what you got the people paid for. In my amendment in lieu for original complaint, I asked the court for leave. I cited in there leave. Not was heard. Court has done me a great injustice. Wait until 5 days before the trial and rule against me on everything that has been pending since January of 2025. I have not gotten a document. I have not gotten even my claim from them. I've asked them for my claim. I haven't got nothing. And they grant you, because he's an officer of the court, you grant them everything. I presented in person and I presented this. Okay, come back here. This is the people's court. It's not the judge's court. It's not the lawyer's court. It's not my court. It's the people's court. Look at the laws. I can ask to move this to circuit court or had it you dismissed. I'm not sure. I presented this in person and I presented it with prejudice this date. September 19th, 2025. Thank you.
I don't know what you're asking for, sir. Are you asking that this file be dismissed? Is that what you're saying? Is that what you just said, that you're going to dismiss it and refile in the circuit court?
That's not what I said. I asked you if I have the right to move this to circuit court.
Circuit court jurisdictional has to be over $25,000.
Okay. And you can move that anytime to circuit court, right? Yes or no? I'm just asking you a question, Your Honor. I'm not challenging. You should know this.
So where we're at, Mr. Kasarsik, is that this case is going to continue on Wednesday.
Okay? Can I move the circuit court before then if I so choose? And refile in circuit court?
This is scheduled for a trial to begin.
I understand that. I understand.
Allow the court to speak, sir. The court is the court will have a full jury panel in 8 a.m. on Wednesday. The court anticipates both plaintiff and defendant to be present by 8 o'clock as well. This is not going to turn into a circus on Wednesday, sir.
It's been one since we started.
You are not allowed to talk out of order, and you will be expected to follow the same rules that the defense attorney follows.
How about
That includes not talking when it's not your time to talk. Okay?
Yep.
So if things are going sideways during the trial, the court has lots of different remedies it can utilize. And right now, the court is taking under advisement request for sanctions. And the court could order actual attorney fees. The court does not know what Mr. Strudmore's hourly rate is, but I assume it's quite high for a lawyer that's been practicing as long as he has been. This will be a trial on your original complaint about whether or not your vehicle was damaged by hitting a pothole and what the cost of that would be, and if that was covered by the policy. That's what we're here for. We're not here for this dog and pony show. We're not here for anything else. We're here for a clean trial, and that's what we're going to run. One moment, okay? If there's any resolution, the court needs to know by noon today. If the plaintiff intends to do anything other than run a trial, the court needs to be made aware in the next 35 minutes, because there are other cases that need to be resolved with trial. So basically, sir, I'm giving you the next 40 minutes to figure out what your plan is, and if it's to keep it on for trial, that's fine. We will have that trial. In order to establish causation, the court has some serious questions about how that will be established.
You
The
got it,
plaintiff-
got it back.
Go ahead. Mr. Kasarsik wanted to address the court very briefly, and then I'll hear from you, Mr. Strudmore.
Thank you, Your Honor.
In the policy signed by Richardson, you're not allowing him to be here. Who's gonna address the issues in the policy? I have a strategy.
The CEO of this insurance company is not required to be here. That CEO of the insurance company does not look at every single policy that's authorized by their company. That is ridiculous to even assume that, sir.
Then I'm asking, who do I subpoena this, the question?
The court can't give legal advice, as you are aware.
But you shoot me down on everything. It doesn't matter who I put in there.
Okay,
I could put in Kurt Harding, I could put in this guy, they had 4 attorneys, I could put any one of them back in there to help me. You shoot me down and keep allowing them. He didn't even get in time for the last hearing on the summary disposition. He was late, but he went to the Second Circuit Court and got in. So this court is kind of the Second Circuit watching over them, so now everything went against me sideways?
Maybe having several years of law school helps in these types of situations. I don't know, just the theory that I have.
Mr. Scrumore, you had something that you wanted the court to be aware of?
Yes, I would just like to make a brief statement, Your Honor. Based on what I understand the evidence will be, and that is that the plaintiff will not be able to produce an expert witness who is qualified to express an opinion that any damage or need of repair of the plaintiff's vehicle was caused by a pothole. And if he cannot do that, I will move for directed verdict and ask that the court dismiss the case. Now, what I'm willing to do right now, if this case is dismissed within the next 30 minutes, I would agree to waive any right that I have to sanctions, attorney fees, and costs if the plaintiff agrees to dismiss this case with prejudice right now. Otherwise, if he does not, I just want to put the court and plaintiff on notice that I will be aggressively pursuing taxable costs, interest, or maybe not interest, but attorney fees for and the sanctions that I previously requested. If it's not accepted by noon today, that offer is off the table. That's all.
Can I come back? Keep asking for this. Yet you have failed yet to sanction him or say anything about winter tampering. You have failed to say that he's intimidated. He told me the last time he was going to be aggressive. Okay, here's some more. Andrew left the courtroom, shook my hand before, left the courtroom with him talking, left the building, went out my money. What did they discuss? When I called him to thank him, Andrew became hostile. He's one of my witnesses. Okay? He told me my signatures meant nothing on these because I wasn't an officer of the court. He didn't even look at some of this stuff. I believe the court didn't either. That I'll leave that up to you, that you weren't here for most of it. There was another judge. He wanted repeatedly to get me to give him my strategy, what I was planning to do, how I was going to go about this, and when I did, then he became, well, I'm going to go aggressively against you, and I'm going to do whatever I can. I'm going to put you in the stand, and I heard 45 cases. I tried, and he's going on and on and on. I still don't have a copy of the actual claim over a year later. Still don't have it. I only got the policy August 26th. Intimidation means nothing. Witness tampering means nothing. Jury instruction. I would not agree to his instruction. So he said he's going to tell the court that we couldn't come to an agreement.
I'm going to pause you right there, sir. The court is the decider on what the jury instructions ultimately are going to be. The court requested of both plaintiff and defendant to provide jury instructions by number. Both sides did. Mr. Scrodenborg provided approximately 20, and plaintiff provided approximately 100. The court went through every single jury instruction and indicated which ones were stricken. That was provided to both plaintiff and defendant with their original list with numbers checked off, which would not be supplied to the jurors. The plaintiff then subsequently, in the last week or two, refiled jury instruction, new set of jury instruction with a
Not the last week or two, no.
with a vast majority of the ones that were previously stricken.
I filed him 7 days after he never obeyed your order to come back with jury instructions. He said he was going to get them to me, and I waited on him, and I never got nothing. Like I said, I believe that because of I'm representing myself, the court picks and chooses what they want to hear. And I will say the same thing when we go to jury trial. I'll tell the jury the same thing. Unless you control and not allow me to speak. I hope this is all on record. Last, I want a transcript because a lot of it gets missed.
The plaintiff filed his proposed jury instructions on September 5, 2025. So that was 2 weeks ago.
Got it.
And the vast majority of those were instructions that were previously stricken by the court. And for the plaintiff to come back and ask for something that was expressly denied by the court is just showing indifference to this court.
I never received nothing from the court showing on instructions. There were a bunch of crosses out and check marks and question marks, and there was nothing received from the court showing me what instructions. I've asked him to get instructions, and John wouldn't give me anything.
So where we're at, sir, in order to establish your claim, the court had some serious questions about how that might be met. Hypothetically, even if this shopkeeper were to say that
Excuse me.
No, you may not talk while the court's talking. Even if this hypothetical expert were to testify about damage, he would not be able to speak to causation because he does not know. He did not see it happen. So that is the issue, sir. How do you establish causation? And if that's not proven, then the defense attorney will be moving for a directed verdict. And that will be the issue. And if that occurs, then you are subjecting yourself to various remedies. So that's where we're at. This case will move ahead with a jury trial. The parties are expected to be here at 8 a.m. Wednesday. We'll start promptly at 8:30. If there are any issues that need to be resolved before the trial, they will be done between that half-hour period between 8 o'clock and 8:30, with the jury rolling in right away. And according to Mr. Strongboard, there's another 30 minutes if you wish to negotiate with him. Otherwise, there's not going to be any sort of agreement beyond that. Okay? Both sides clear?
Yeah, thank you, Your Honor. I don't, I'm not hearing from plaintiff that he has any interest in dismissing the case and accepting my offer that I would agree to that, to a stipulation to dismiss with prejudice upon my promise or agreement not to pursue sanctions. But if he doesn't agree to that, I just want him to know that if we proceed and he fails, then I will pursue the attorney fees and costs that I previously asked for. And so, Your Honor, are we finished?
John, can I address you a second? Where are you out of? Well, I trust you as far as I see you. I hope you're wrong. That's why you're so far away.
Okay, I believe we're all completed. Thank you.
Are we done, Judge?
Yes, we are.
Oh my. Unfortunately, the trial was not aired for public. But hold on, let me put this down. And when we look back at that Michigan case search page, right? It shows that the claim is still open. So, yeah, if we look right here, I don't know if you guys can see my mouse or not, because I don't know with, I can't see what you see at the same time you're seeing it. But if you look right here for case status, it says open. It shows that it was filed 11/8/24. Oh, and there's another page. Oh, no, that's just, never mind. That's all of the people Mimic is suing and vice versa. But yeah, for the open case, let's see the most recent events. So November 5th, an order was entered. On 10/27, proof was filed. Notice filed 7-day rule. Okay. That must be another attorney for that law firm. Because here's the one that we just saw. John J. Schrattenborer. So this Christopher James Acklin is another attorney out of that law firm. But yeah, it looks like they're filing answers, proofs, briefs, appearances. Yeah. I don't think that guy's going to prevail. He's trying hard, but he doesn't have a case. I don't believe he has a case. Thank you. I've always wondered. And now I know. Right. Yeah. Oh, but it's a dust cover, remember? Allegan County, 57th District, Michigan. I know, I wish I could have. I'm so sorry. But it's not over. Schrattenborer, Worcestershire, Worcestershire, however people say it. I don't know. No, not at all. All right, guys. It is 1 a.m. I've got another hour, but I think I'm going to play it tomorrow since tomorrow is Saturday. Since I already have it ready, I can play it. I can come on early and we'll do a day shift and a night shift tomorrow. How's that sound? Double the fun. Sounds like you took some Nitol. Oh, I don't know yet. First, I have to see if I can get any sleep. Last night, I didn't get great sleep because I ran out of distilled water on Christmas Eve for my BiPAP machine. So Christmas Eve night and Christmas Day night, I had no water in my BiPAP. I woke up and my tongue was fuzzy, feeling. Like, it's terrible to just have forced air blowing in your mouth all night long and wake up and your tongue is just dry. And it's soft. It's super soft when it's dry. But it didn't feel right. And then, of course, being so dry, then it dries out my throat. Yeah. So I had 2 jugs of distilled water delivered today, and hopefully I can get some decent sleep. You can't for medical equipment, you can't use boiled water. It's not the same. You could use the steam from the boiled water because that's distilled water. But you can't just boil the water. You're not trying to kill microbes. You're trying to remove all the minerals because the minerals in the water are what can foobar your machine. Yeah, it's a process. You're playing a risky, expensive game, my friend. So, okay, here's a funny little story, right? Hold on, I have to cough. Okay, story time. So, this was one my father had told me. There was a man who owned a small dentistry, and he had owned it forever. All of his equipment was that that I don't know, 1950s asylum green color is the only way that I can describe it. Like all of the equipment was this eggshell yellow and well, a little darker than eggshell yellow. I mean, it was just for those of you who are familiar with that old-timey equipment, you know exactly what I'm trying to express here. So anyways, he had all of this old equipment, but it was the most popular dentistry in the area. And there was larger dentistries that were trying to buy him out, and he didn't want to sell. Something happened, and I don't recall the details of the story of what it was. But he ended up having to sell to one of the larger dentistries, and they said that they were going to fire all of his employees and bring in all new crew, and that didn't sit well with him. He was a man of honor, and the original agreement was that they were going to keep all of his staff, and that's the only reason that he agreed to sell to that firm or dentistry or whatever it was. And then they said, we're going to come in and we're going to fire everybody. So the dentist told his secretary, gave her a note to go purchase water for the machines. Well, he just said purchase water. And they left gallons of jugs of water there for all of the equipment. But it wasn't distilled water, it was mineral water. And within a few months, absolutely all of the equipment was broke down. And the larger dentistry had to close the doors because it wasn't cheap to replace all that equipment. So, yeah, they had to just shut the doors of that dentistry down and I don't know if they reopened under their own name or whatever they did. Basically, like, the guy didn't, he just, it was his one last hurrah. He didn't do anything wrong. He just didn't tell them that they had to use distilled water. But the minerals in the water will kill the finite equipment like that. And you can't just like use vinegar and clean it out. Not when you're working with intricate equipment like that. Yeah. So I know I didn't tell the story as well as my dad, but it was my dad told lots of stories like that. My dad knew a lot of people and in a lot of positions. And so he had some really great stories. Yes, absolutely. Asylum green. Like old, I would mean like 50s style is what I would think. I might be wrong on that, but no, the minerals in the water. If you boil water 100% out of the pot, like just put water in a pot, boil it completely out, you'll see this white film all around the pot. That's the minerals. And that's what builds up over time inside of your coffee pot. And that's why on Keurigs and coffee pots and stuff, you get the notification that you have to clean or descale the machine. That's what that means. It means that those minerals, that white film of crustiness that's left over when you boil tap water out, that has built up on the moving parts inside the machine. And you can get rid of it by using vinegar or citric acid to clean it out, but not for medical equipment. You can't get it in there. So hello, Otto of Arizona. Well, you sure sounded like you were confused when you said rust. You asked me if I meant rust. I can't hear sarcasm. I can only see words. I can hear Ava having little dreams over there. She's sleeping on the floor right behind me. And every once in a while, I'll hear her huff. All right, guys, I'm going to go to bed. I'm tired. And I get dumber and dumber the more tired I get. Oh, okay. The water up at the cabin where my ex-husband's family owns cabins in Upper Michigan. They're on Lake Eleanor, and the water that comes out of your tub is actually the water from the lake. And it comes out brown. Oh, I grew up a block away from a river, and I couldn't imagine having river water as tap water. I would need a huge purification system because I'd go swimming in that river and cow pies would come floating past. All right, you guys. I love you all so much. Thank you for being here. Be safe, be well, sleep sweet, and much love.